Hello, students. Today, in this lecture of jurisprudence, we are going to study the Renaissance theories on the concept of natural law. During the Renaissance period, there was a general awakening of various new ideas in all the field of knowledge. During this period, new and developed branches of knowledge and various discoveries of science had laid down the foundation of established value for the society. During this period, number of development had been taken place in the field of commerce, due to which there was creation of new classes in the society which wanted more protection from the state. Colonization also caused rivalry among the states, which gave birth to the concept of nationalism in various states. And this concept of nationalism argued that the state must have full sovereign power and the dominance power of the church should come to an end. All these factors, when combined together, created forces which overthrown the dominance of the church to make the laws, to interpret the laws. During this period, various new theories which had spotted the sovereignty of the state were propounded by various jurists. During this period, reason was the foundation stone of all these theories. But it is very important to note here that reason, which was the foundation stone of all these theories during the Renaissance period, was the secularized reason. It is very important. The reason during this period was the secularized reason. That was not the theological reason. That reason was not based on any particular belief of religion, which was the base during the Dark Age and medieval theories by Catholic Christian fathers. I want to repeat it. During this period, the reason was the secularized reason and not the theological reason, which was the reason during the Dark Ages and medieval period by the Catholic Christian fathers. In Renaissance theories, all the theories proceed from the supposition that a social contract is the basis of society. So, what is the meaning of social contract? The concept of social contract can be understood by the following points when we do it in sequence order. First of all, to understand the concept of social contract, we have to go back to the beginning of a man. When in the beginning, man lived in the natural state, there was not any concept of government, there was not any concept of society, and there was not any concept of law for the man. He was living like other animals on the planet. This beginning state of human beings has been described in two ways by jurists. In the first way, the jurist said that the beginning state of human being was in the nature of hardship and oppression because he was living like an animal. Hence, the jurist came in the spot of the absolute power of the state, who can protect the man from all types of dangers. Whereas, in the second way, the other jurist considered the beginning life of man as full of bliss and joys, and they support the freedom of the individual, and they also support that there should not be any type of state which will interfere in the freedom of individual. We will discuss both types of thoughts in this lesson. With the passage of time, first of all, men entered into agreement with each other. I am repeating here, with the passage of time, first of all, men enter into agreement with each other, not for the creation of the government, but for the creation of the society. Why they had made this type of agreement? Only for the protection of their lives and property. So, let us see what is written in the notes. With the passage of time, the men entered into agreement with each other for the protection of their lives and property. This agreement between men is called pactum unionis. This is very important question which can be asked in the examination. What is pactum unionis? When men entered into agreement with each other for the protection of their lives and property, this agreement between men is called pactum unionis. Through this agreement, society came into existence. I am here saying that society came into existence, not the government. Under this agreement, men undertake to respect each other. All men say that we are respecting each other. I will not interfere in your business, and you should not interfere with my business. You should respect me, I will respect you. And we should live in peace with each other. And there should not be any type of disturbance by the agreement of pactum unionis. Under this agreement, men undertook to respect each other and also undertook to live in peace with each other. After making pactum unionis, men think that this is not enough for the protection. For more protection, there should be someone who will protect to us. So, men entered into a second agreement by which they had united together and undertook to obey an authority and surrendered the whole or a part of their freedom and rights before an authority. And the authority to whom they have surrendered their whole or part of their freedom and rights, given the guarantee to every one of them that I will protect your life, property, and to a certain extent your liberty. Thus, in this way, government, sovereign, or ruler came into existence for the protection of the rights of individuals, and this agreement is known as pactum subjectionis, when they subjected themselves before a sovereign. What is the implication of this social contract theory? There are two implications of social contract theory. The first implication is that the people are the sources of political power because People are giving the right to a sovereign when they subject themselves before the sovereign that you are the protector of our freedoms. So, the source of political power is the people. This concept says that people are the source of political power. And secondly, the concept of society of this philosopher is individualistic, in which the attention is to be given to the interest of the individual. This is something about this lecture. If you like my video, then please subscribe my channel. If you want to get notes of my law lectures, then you can go to lawarticles2020.blogspot.com. Okay, in the next lecture, we will see the theories of various jurists who has given their theories during the Renaissance period. Thank you very much.